For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Good evening. My name is Joe Sam Robinson. It's my pleasure to have with us our very frequent guest, Mr. Buck Melton. Welcome back, Buck. You've been here a lot. We've had lots of interesting discussions. Most of our discussions center on, I guess, the United States Constitution, the government, our present political, social, economic situation, how the Constitution impacts things, the direction of the country and our complicated life. And one of the things we've spoken about in the past is the idea of the branches of government in Washington being in conflict. Yes. And so I guess the issue is, if I can throw you a little softball here, the issue is that the executive branch seems to either propagate quasi-laws or not enforce the laws on the books. That's making the House of Representatives, controlled by the Republicans, angry, if I could use that word. And they've been unable to have any legal or court intervention because they lack standing. Now, what on earth does that mean?
Yes.
What is standing? What's that concept?
Well, it's a concept that falls under a larger concept of justiciability, which is one of these fancy words that lawyers like to throw around. And justiciability is the question essentially of is a conflict something that the courts either can or should get involved in attempting to address or attempting to hear. And over the decades, the Supreme Court has come up with several different rules for justiciability, about 5 of them, and one of the big ones is standing. Yes. And the question of standing is, has the plaintiff in this case, the person who is actually purporting to bring the lawsuit, has this plaintiff suffered an actual injury because of the law or because of the action of the defendant that the courts can give some sort of meaningful redress for. So, for instance, if there is a traffic accident out in California between 2 people that you've never heard of before, could you be an officious intermeddler and you, Dr. Joe Sam Robinson, sue one of these people in California, one of these motorists who've been in an accident? And the courts would say you have no standing. You haven't been injured. You have no relationship to the facts of this case, and therefore get out of court. So,
well, I mean, okay, I can accept that concept. Your analogy with the traffic accident in California sounds quite reasonable. But in these enormous tectonic plates moving against each other in Washington, that seems like almost anyone would have standing. If a law is not being enforced, let's say, I don't know, with illegal immigrants, the executive branch decides, here's the law, we're just not going to enforce it, and an illegal immigrant hits my, I don't know, trips me in the supermarket or takes some of my tax money. It seems like millions and millions of people would have standing.
Yes.
And in every one of these issues. How could people not have standing? The brush of the executive branch is so broad. Millions and millions of people are impacted by this. I mean, yes. Can you speak to that? Why aren't there just thousands of lawsuits about this?
Well, there are 2 or 3 different rules that the courts have developed for standing. When I was talking about California, I gave one of them as an example. That's called no third-party standing, that you cannot bring another person's rights into court and try to plead them. The situation that you've described comes under a second of the standing tests, and that's called, and this is a weird one, this is paradoxical, called generalized grievance, which means that if this law or this problem affects everybody, then nobody can sue. Nobody has standing. The rationale the court uses for that is if the problem is this broad and it's affecting this many people, then the appropriate remedy is to go into the voting booth and vote the bums out.
Now, is that a cop-out? I mean, I'm disturbed by that train of logic.
Yes.
And so what happens to a private citizen when we're out here in Middle Georgia, we see something, and the Supreme Court presumably has fashioned some kind of substantial defense of a bad situation. What does one do about that? I mean, you can't. Can you challenge it again? I mean, this presumably is something that it's not something written down in a law book. It is just a series of decisions that have been made. But I mean, and my understanding is the Supreme Court just can do what it wants to in regards to these issues. Do you have thoughts about that? I mean, how hard is it to pierce this logic that's been presented?
Pretty difficult. What you say is something very interesting. Charles Evans Hughes, who eventually became Chief Justice of the United States, but before he was Chief Justice, and I believe that he said this before he was even on the Supreme Court at all, he once said that the courts are under the Constitution, but the Constitution is what the Supreme Court says it is.
Yes.
Now, the Supreme Court claims that that what it's doing is elaborating upon the Constitution with this idea of standing. And a lot of the justiciability issues goes to a provision in Article 3, the judicial article. It's usually called in shorthand the cases or controversies requirement, that the Supreme Court and the lower federal courts can hear these sorts of cases and these sorts of controversies. And if you don't have standing, if you don't have skin in the game, then it's not really a case or controversy. Now, yes, that's based on a judicial gloss of the cases or controversies clause, but the courts will say, well, no, this proceeds from the Constitution. We can't change this. We can't muck around with it.
Well, I'm unconvinced, and I'm going to squeal. I'm going to squeal about it. And the one reason I'm squealing about it is if there's a major impasse between the executive and the legislative branch, and either of the branches. I mean, right now we're using the example of the executive, but presumably it's the way the legislative branch could do something. They're just at loggerheads, and
Yes.
you could make a case the executive branch decides whatever they want. They're not going to collect taxes. They're going to just close airports. They're going to I don't know what create an order of knighthood. I'm joking slightly, but
That one you
I
can't
know
do
it's
either.
against the Constitution.
Yes.
Well, they could be something they could do. I don't know, some kind of just one nutty thing after the next. And the only way that the seemingly, besides impeachment, the only recourse is for the courts to referee this. That would be my thought about it.
Yes.
And if the idea is the voters can do something about it, the executive is in there for 4 years, and he's going to be there. And presumably, if the executive only has 2 terms, there's nothing the voters can do in the second term of an elected president. The ballot box doesn't work, and it sounds like a very contrived legal explanation.
Well, I will
See how
play.
mean I
Yes.
am, right?
I will play devil's advocate for a bit. That the courts say, and I think there is some truth in this, that if you relaxed the standing requirements, you would flood the federal judicial branch with so many cases of each individual person trying to nullify the law that the courts wouldn't be able to accomplish anything. Now that I think there is some truth in that, but the other side of that is how many people are single issue voters? How many people are going to change his vote for his particular congressman on the basis of one issue that he does not have standing to bring a case for? And it's sort of like impeachment in that the remedy is an extremely difficult remedy to achieve. Congress has been getting approval figures down in the single digits lately, 9%, 10%, and yet 80 or 90% of members of Congress who run for re-election get re-elected. So that means that the court's rationale for standing, that if you've got a problem here with this generalized grievance, all you people go out and change your elected officials, isn't really workable.
Well, I'm going to, once again, I'm going to squeal about this.
Mm-hmm.
And, the normal person walking down the street eating a hamburger, that's something that just doesn't enter their normal life. But what does enter the normal life is the government it contempts the different branches of government can't cooperate. And then one branch just decides, well, I'm just going to do whatever I want to. And the remedy that's suggested by the courts is just an ineffective remedy The only other thing that could be done would be impeachment, which would be just an extraordinary atomic bomb step to take. And the logic that's just been presented is the courts would be overwhelmed with litigation. But it appears to me the courts have a methodology to deal with that in class action arrangements. So many people sue, I don't know, General Motors about the defective brakes, or thousands of people sue about pollution, or just hundreds and hundreds of thousands of people are out there. And the courts have a methodology, do they not, to collect these different cases and put them under one special master, or whatever the terminology is,
yes.
some person that's going to ramrod this.
Yes.
It appears could that be employed here to resolve the tension between the branches?
Yes. I suppose it could be, but once again, if you get all these people together and have their interests represented in a class action or by a special master, then it starts to look like, if you will, a shadow election or a shadow government. And once again, I'm playing devil's advocate here, that if you're going to go to all that trouble, then why not just, by the time you've gotten the class and certified the class and got the filings, you're to a midterm congressional election anyway. And so you don't want to second guess the election and have a group of voters telling all the voters that they can't do this. So,
well, I mean, that's I'm not okay.
Once again,
that's an
I
opinion.
don't,
I mean, I'm still okay.
Yes,
I'll
I don't
take
necessarily agree with it. I'm just trying to look at the other
there's an
side
argument
here,
to say. I mean, I guess the issue is that we have such fast-moving events in the world.
Yes.
And we depend on the process to sort of inculcate justice and civility in our world, and we want everyone to collaborate and make things work. And if there's no way the courts just have said, I'm not going to get enmeshed in this, which presumably they said, I mean, isn't that a cop-out? I mean, why shouldn't the courts just at least referee it a little bit? And it does seem like there should be some kind of, I guess, guidelines about what the executive is required or not required to do. And if the guidelines are violated, there'd be some kind of lesser remedy than impeachment.
Yes. Well, that was very heavily discussed during the Bill Clinton impeachment. There was a lot of discussion about a congressional censure of the president. And a lot of people responded, there is nothing in the Constitution that allows a censure, that the censure that is allowed is impeachment. Now, that being said, there have been presidents that have been censured before. Andrew Jackson, I believe, was censured by the Senate, and then the Senate later expunged that, if I'm remembering correctly.
Yes.
But it's a result of the way the Constitution has developed. There are some arguments that impeachment originally was not a truly extraordinary remedy. That if you look at how the Electoral College was designed, that absent political parties, the House of Representatives would get to decide who was going to become president a good bit more often than has actually been the case. That's actually only happened a couple of times now. And so the Congress, under that model, would take a much more active role in choosing a president and also take a much more active role in removing a president through impeachment, which could become sort of a vote of no confidence. That's not the direction the Constitution developed in. The impeachment power developed into this cumbersome atomic bomb power that has been used very rarely in American history. And now the Supreme Court and the federal courts are contributing to the dysfunctionality by saying, not my job. If you've got a problem getting the bums out some other way, that's not the court's problem, that's yours.
Well, now, I think I've sort of bounced the basketball a bit on my views on standing. One of the things that apparently is taking place is in the House of Representatives, they're attempting to fashion some kind of document or a case in the courts that that particular body has standing because the executive is not enforcing their laws. So they're going to try and go that direction.
Yes.
Do you have any thoughts about that? I mean, could the whole branch get together and then say, we're going to, presumably the Democrats would not vote for this, but the Republicans control the branch, so they would just put a I guess, a resolution through saying we believe we've been slighted and we ergo have standing as the whole branch has been injured.
Yes.
Is that a way to go with it?
It's a possibility. Once again, if you grant the concept of standing, which you might not, and I understand that, then the response would be that the entity that passes the law is not the House of Representatives but Congress as a whole, and that you could make an argument that therefore Congress as a whole institutionally, that is both the House and the Senate, would have to sign on to this. And so the House by itself, just signing on to it, that's going to look very partisan. And at that point, you get into another question of justiciability. Standing is one of them. Another one is called political question. And if you don't like standing, you're going to hate political question because it's a real mess. The Supreme Court says, and the lower courts have followed this, of course, that if you've got something that is better, just better decided or better resolved by the political process, then the courts shouldn't get involved with that. So if Congress has got a real problem, they need to impeach the president. They need to do that.
Yes.
So,
Well, let's go into another sort of example that's out there. We have a huge event in America, which is the Affordable Care Act. And presumably what's taking place, and this affects every human being that walks the street. It impacts old people, little people, big people, sick people, well people. Everyone in the country is being affected by this, and there's a law there that the executive branch chooses to enforce or not enforce, and presumably just do what they want, against the will of Congress, or at least the House of Representatives. What I'm hearing is that the Supreme Court has put roadblocks up for a private citizen to say, look, I don't accept this. This law is not a law. It's an executive. The law has been mutilated by the executive branch, and it's enforcing this mutilated imperium on my life. And I'm an American citizen. I don't like this. I want to go to the courts, and I want to say I'm getting injured by this decision, and the courts are telling me, as best I can interpret it, number one, you don't have standing because it's a general problem. It's a political
generalized
issue.
grievance.
So, and the other thing is, there's not, if I can say it this way, unless the president is impeached and a new executive goes in there, there's not anything that you as a citizen can do. There's not a thing you can do, nor can your elected officials do anything. So the elected officials can't do anything. Which brings me to the other idea that's out there, as we have this enormous, I guess, difficult period in our history with healthcare, and since I have a role in healthcare, it's of substantial interest to me. But is there an argument that the states, let's just say the federal executive branch is propagating a particular illegal dogma? I'm calling it an illegal dogma. And the courts refuse to do anything about it. The only option is for the legislative branch together to impeach the president, which would be politically impossible. We're just going to have to endure this to the injury of the country and many of its citizens. So that's not an optimal situation. I think the courts, I'm very displeased with this legal train of reasoning, and the courts need to understand that I'm displeased, but okay. I'm sure they'll take it okay. But the states, there's a story out there, at least, that the states are saying, we don't have to be enmeshed in this. The connivance, we don't have to connive with the government to enforce this, and we're going to just pull out. And I think there's in South Carolina they're doing something, and I guess the train of logic is that in the decision made by the Supreme Court at a 5-4 decision about the Affordable Care Act, the states were given a out with Medicaid because they don't have to. They're not being forced into it. And along that chain of logic, could all of the local governments just not participate in what's construed as an illegal usurpation of power? It's just an illegal action that's being propagated by the executive. Could they say, we're not going to do this? I mean, is that your comments about that? Have you heard that?
Well, I've heard something similar. It would take a long time to unpack everything you've said, and there are a lot of very interesting points in it. One thing that occurs to me on that is exactly down the road you're talking about is that the states that have not chosen, or rather have chosen not to establish state exchanges, the federal exchange is going to cover those states. It turns out that the actual Affordable Care Act itself, the law itself, does not allow federal exchanges to provide tax credits to people in need of those tax credits who get their insurance on the federal exchanges. Only in the event of a state exchange
yes.
can you get those tax credits. So guess what the IRS has done? The IRS has set forth a regulation giving those tax credits anyway, when the Affordable Care Act does not
yes.
allow that.
Yes.
Talk about rewriting the law. This is
yes.
a classic example of it. So it looks like in this case the feds are just going to do it anyway.
Well, now that's not a very optimal situation, if I can.
Well, it's an illegal situation.
Well, we're a nation of laws
yes.
here, and it appears to me the courts have responsibilities to basically arbitrate these issues and make sure that the rights of the American citizens are being protected. I mean, that's their central obligation. And I mean, when I hear the story about this whole notion of standing, I mean, it just seems inappropriate.
Yes.
And we ought to have some kind of way to do something about this. Now, and presumably other court challenges are going to appear here. I mean, isn't that, do you think the Supreme Court would understand they've made an error?
Yes.
And do they sometimes think, well, I tried to do this, well, maybe I'll pull back a step? Any thoughts?
Well, there is already, regarding the IRS reg that I was just talking about, that case is already underway. It was filed a few months ago, I believe, in Oklahoma. As regarding executive action in general, there is surprisingly little case law on that, on can a president, and usually the issue is, can a president refuse to enforce a law that he believes to be unconstitutional? And in the case of Obama just delaying some aspects of the Affordable Care Act, of Obamacare, he certainly doesn't think it's unconstitutional. They have argued vigorously that this is a constitutional and a highly desirable law.
Yes.
He is being motivated, as far as anyone can tell, by purely political concerns. So I've never seen anything quite like this. But there's very little case law on it, partly because of the same standing issue.
Well, now, isn't there a lot of, as the government grows more powerful, and you could make an argument that, okay, a powerful government is needed because we're such a complicated country, and how are we going to make sure the air is clean and that we can eat safe hamburgers and drive to Atlanta without difficulty? I mean, all the things that, the responsibilities of the government are a lot more now than they were 200 years ago.
Yes.
I think everyone would agree with that. But the regulations that seem to be propagated are independent of the process by which laws are fashioned in the country. I mean,
Yes.
and we talked a little bit about President Obama and what he's up to, but don't different kinds of regulatory bodies just do this routinely? I mean, maybe the law says you're supposed to have, I don't know, your carbon emission number is supposed to be 10, and then
Yes.
the commission would just say, well, we're not going to really say, it's too hard to do it right now. We'll give you another 5 years, even though the law says 10. And can they do things like that?
Well, yes, and the number of federal regulations out there, which are promulgated by any number of federal agents, is simply staggering. I forget the figure for Obamacare itself, but something like 70,000 pages of,
Yes.
and it's becoming almost impossible even to know the law. And
that's
when
no
you get to
excuse,
a
is
situation
it?
like that.
There's no excuse if you don't. I mean, what happens if you're just a rather, you're a busy anybody, a busy doctor, a busy anybody, and there's some kind of extraordinary set of regulations that is just unknowable as to what these regulations are, and someone could say to you, well, you know, you're guilty. You've sinned because of Regulation 23.642, and we're going to give you a terrible nip. And I mean, is that?
This is why small businessmen are having such trouble right now with the current administration. They're saying that these regulations are just too burdensome. I imagine there's somebody in your practice whose full-time job is just to keep up with your state and federally imposed legal obligations.
Yes.
So yeah, and that's a problem, and especially when the idea becomes that the solution to any given problem is let's pass another law. And if the laws are not being enforced, if the laws are not even properly understood, that kind of knee-jerk reaction is not going to be helping the situation whatsoever. So the current administration does not even understand what is in the original
Yes.
Obamacare law, or they wouldn't have gotten into this problem with the federal exchanges. And yet
Well,
we have.
you know, I think we try and be neutral here. I mean,
Yes.
we, you know, everybody, we want the country to work. We want the Democratic Party to do as well as they can. We like the president to do. Everybody, we want success. But it does appear that someone has blundered. If I could, you know, quote the charge the light brigade, someone has blundered, and we need to say, you know, very loudly and in every venue possible, let's re-examine the process by which this happened. I mean, and that's
Yes.
where the blunder occurred, I think, in the process.
Well, I think the basic problem is that government is so big now, it has an inertia that the bureaucrats are not elected and therefore not really responsible, even to Congress, barring the same sort of drastic action as you see in an impeachment, like abolishing the Department of Education. It's hard to change this inertia. It's not responsive.
Well, Bucky, thank you for your interchange.
sir.
We'll talk some more on similar subjects. Thank you. You did well.
This program is brought